All rise. We would away. Please be seated.
Mr. Jordash, do we correctly assume that you and counsel for Mr. Simatovic have decided to divide your time equally and that you would therefore be winding up at 1?
Yes, Your Honour, that's correct. The prosecution's approach to Stanisic's alleged contribution to the Bosnian Serbs' common criminal purpose is similarly premised on systemic misrepresentation of evidence of relationships and activities. We will address this in the last remaining 30 minutes. Again, it's worthwhile first looking at Stanisic's most basic relationship, whether he used his career expertise in intelligence to coordinate and support Karadzic, Mladic, Micho Stanisic, and other Bosnian Serbs. At paragraph 11, the prosecution claimed that Stanisic provided intelligence support in furtherance of the common criminal purpose in Bosnia. But this is manifestly not what the evidence shows. To the contrary, as we discuss at paragraph 986 to 993 of our final trial brief, the Bosnian Serbs themselves didn't arrive at this conclusion. Notably, RFJ 170, the VRS deputy to Mladic, noted the DB's refusal to cooperate was a, quote, continued topic, close quote, of concern for the VRS. More crucially, as we have argued, the DB's so-called intelligence collaboration with the RS through Typhoon, Sigma, and Miloš were regarded by the RS as hostile acts. Typhoon was regarded by the RS as a suspicious, quote, foreign service, close quote, aiming to obtain material, quote, to discredit the RS, close quote, topple the RS leadership, and spread defeatism. Sigma, its successor, was regarded by the RS as a means for the Fry to encourage a change in the RS's leadership's obdurate refusal to negotiate for peace. Milos, as shown at page 1 of P00385, was regarded with equal suspicion. The prosecution cannot simply ignore this evidence. It evidences a relationship of mistrust and antagonism that sits at odds with the prosecution's overall case that Stanisic was coordinating their criminal purpose and lending them his assistance in every other conceivable way. Why, if Stanisic was helping Karadzic and Mladic through sharing intelligence, supporting the RS MUP and the VRS, deploying Arkan, the Red Berets, and the Scorpions to support their ethnic cleansing campaign, would the RS distrust Mr. Stanisic's basic intelligence functions? As I said in relation to Croatia, seems a bit churlish, to say the least. If, as the prosecution alleged at paragraph 2029, Stanisic played a key role in coordinating relationships between the Belgrade and Bosnian Serb leadership, including Krajisnik, Karadzic, Micho Stanic and Mladic, who, quote, sought advice from Stanisic and Milosevic about everything, close quote. Why, shortly thereafter, do they regard Stanisic's DB with such suspicion? Well, the evidence, or the lack of it, speaks for itself. Despite this outlandish claim, there is literally no evidence that Stanišic was in communication with Krajšnik or Mladic in 1991 or 1992, or even thereafter, that he was in contact with them directly. The same is true of Plavšič. The same is pretty much true of Micio Stanišic. Read the Mladic diaries and this is crystal clear. Stanišic barely figures in it, and never does Mladic identify Stanišic as having authority over Arkan, the Red Berets, or the Scorpions. Never. Indeed, not once does Mladic indicate that he has a personal or direct relationship with Stanišic. No wonder Milovanovic, Mladic's deputy, as he testified at P02934 T4533, mistook Stanišic for a waiter. And that was in 1993. Read RFJ 037's evidence at P01616. The main evidence the prosecution rely upon as the basis for their claim at paragraph 229 that Micio Stanišic was responsible to Stanišic and consulted him for everything. Based on what? Real interaction? No. Based on evidence of procurement in furtherance of crime? No. He'd seen the two men speak near the Federal Sub-Building. The claim at paragraph 482 of the prosecution's final trial brief that Stanišic, on behalf of Milosevic, influenced the development of the fledgling Bosnian Serb police through Stanišic is more of the same. It's based solely on a misreading of P0004, an interview with Sešel. Need we say more? The very relationships, as the prosecution know, that were necessary for Stanišic to play the role alleged are absent. Prosecution know this and have strained every sinew to invent them. Even the evidence of Stanisic's relationship with Karadzic prior to the Bosnian Serbs' common criminal purpose fails to support any coordination role in furtherance of the Bosnian Serbs' common criminal purpose. As we discuss in Part 2, Section 4D5C of our final trial brief, Stanisic's main focus in the intercepted conversations with Karadzic is on the RSK and his role in attempting to persuade the RSK extremists such as Babic to agree to the Vance plan. In fact, he refers to them as extremists. He refers to them as Chetniks. He refers to them as incompetent jerks. And yet, Stanišic is supposed to be coordinating their criminal purpose at the same time as coordinating Karadzic's. At the very worst, these conversations show that Stanišic was involved in mid-1991 with the defense of beleaguered Serb villages in Bosnia and Herzegovina. So yes, as the prosecution claim at paragraph 238, in June 1991, Curtis did claim he and Stanišic had carte blanche to arm Serbian villages. But he also said that Stanišic was not able to arm because, quote, the lads didn't do anything all day and one mustn't do anything without Junačkovic. Moreover, what has arming in June 1991 got to do with this common criminal purpose? Not a single case at the ICTY has found there to be a common criminal purpose in Bosnia in mid-1991. The timing is convenient. The prosecution hoped to take evidence of Stanisic's involvement in arming to defend villages and morph it into a common criminal purpose. That's why they plead a common criminal purpose beginning in April, because if they pled it beginning in August, they wouldn't be able to ensnare Stanišic. So when on the 21st of December 1991, as shown in P01590, page 1, Stanišic asks Karadzic, quote, are we going to have our own republic, close quote. It's a genuine inquiry. consistent with Stanisic's intelligence functions. It's a genuine inquiry which shows that he is not designing the Bosnian Serbs' regionalization campaign. When on the 7th of January 1992 in 1D01361 at page 3, Stanišic advised Karadzic that it would, quote, be better, close quote, if the Bosnian Serbs would resolve their differences with the Muslims and Croats, quote, nicely and peacefully, close quote. It is a genuine exhortation, based firstly on SFLY's expressed policy, but also indicative of the fact Stanišic is not supporting the war option, let alone a common criminal purpose. No amount of cutting and pasting can hide Stanisic's complete lack of agreement with war and a lack of planning for any ethnic cleansing campaign. The prosecution's claim at paragraph 477 that following Karadzic's Highway to Hell speech on the 15th of October 1991, Milosevic and Stanisic's support for the criminal purpose did not waver is complete fantasy. In the intercept 1D00075, Milosevic in fact urges Karadzic to calm down, not to create an assembly, because it would alienate the non-Serbs, and to negotiate with Izetbegovic. Contrary to the prosecution's distortion in paragraph 477, and as P01505 shows, in mid-December 1991, Stanišic does indicate he's ready to send some men to Bosnia for some purpose connected to Babic and criminals in Banja Luka. But there is nothing in this call, or any other call, literally nothing to indicate that he is in pursuit of a criminal purpose. Taking evidence, all evidence of activity, and claiming it's in pursuit of a common criminal purpose is not respectful of the principle of culpability. There are many examples in the prosecution's final trial brief of this. Find a paragraph concerning Stanišic, and if we had the time, we'd show you a distortion, a misquote, or a failure to consider relevant evidence. It's a systemic problem in the prosecution's final trial brief. And what Your Honours will find, when the evidence is examined fairly in its entirety, is evidence of association, even collaboration, of issues of concern to the Fry. That's why you see some evidence of Stanišic involved with the protection of Serbian villages in Bosnia in mid-1991. That's why you see clearly his involvement in PALC. We don't shy from that. That's why you see his involvement in defensive operations in 1995 in SPWS and Banja Luka. These are plainly not in pursuit of a common criminal purpose. Of course, the overriding problem in the prosecution case, and this is why they've changed their common criminal purpose, derives from the fact, as we argue at paragraphs 851 to 883 of our final trial brief, is that the Belgrade Serbs, despite prosecution cases at this tribunal for 25 years, despite a commonly agreed narrative external to this tribunal, the Belgrade Serbs did not agree on the Bosnian Serbs' ambition to unify with the Fry. If they had agreed with it, why did they simply not do so? What was stopping them? Why, if Milosevic supported the Bosnian Serbs' march to war, did he urge Karadzic to negotiate with the Muslims? Why, in October 1991, when the SDS in Bosnia were taking various steps, including the creation of the Bosnian Serb Assembly, did Milosevic urge Karadzic to refrain from this campaign? Why on the 24th of October 1991 did Milosevic attempt to persuade the Bosnian Serbs against establishing their own assembly? And why, crucially, and this is, I think, the crucial point here, Why, as Donia described, did Milosevic and the SFRY on the 2nd of March 1992, just as the Bosnian Serbs war was beginning, refuse to allow the Bosnian Serbs on the 2nd of March 1992 to have any formal links with the republics of Serbia and Montenegro? We still don't know that answer from the prosecution. Why? If there was a grand plan, why? As we discuss at paragraph 880 of our final trial brief, it was Karadzic and the Bosnian Serbs who believed that severing their connections with Serbia and Montenegro would result in a, quote, catastrophe, close quote. Not the FRY, not the SFRY. So if the prosecution case is correct, just as the Milosevic and the FRY were abandoning the Bosnian Serbs in late 1991 and early 1992 in their desire for unification, the prosecution's case is premised on the fact that Stanišic was behind all of this, plotting with Karadzic, Mladic and Micho Stanišic to supply hundreds of thousands of tons of weaponry, to create an elite DB unit to deploy alongside Arkan and the Scorpions, and a myriad of other paramilitaries in Bosnia to help them achieve the very unification with the FRY that had just been rejected by the FRY. No wonder the prosecution are seeking to abandon their common criminal purpose. The Bosanski Samaj crime base is a case in point. We don't have the time to examine all the crime bases, but it's worthwhile examining this to see the prosecution's approach and how they try to overcome this essential foundational problem. As paragraph 1008 to 1094 of the defence final trial brief makes clear, Stanišic did not command or exert authority, as the prosecution would rather have it, over the unit or any associated men in Bosanski Samaj. Paragraph 124 to 125 provides the perfect illustration of how the prosecution used the unit to circumvent evidence of real command, control, or procurement. These paragraphs, and tucked neatly away in footnote 524, contains a list of alleged unit members who deployed with Cerney, namely Avramovic, Kolobric, Korf, Lazarevic, Luga, Mitic, Debeli, Simovic, Subotic, and Vukovic. The prosecution barely attempted the necessary minimum analysis to link these men to Stanišic. The unit is supposed to do the heavy lifting. It's the prosecution's Trojan horse. In this way, the prosecution implicates Stanišic as being in command of men without fulfilling the tools test. The fact is that of these men, only Cerney, Subotic, and Alexander were prospective members of the nascent units. The remaining 8 men do not even contain or have this elementary connection to the accused. They are linked to the accused merely through association with Cerney. As a preliminary point at paragraph 125, the prosecution alleged that the personnel files of Cerney, Luga, Kolobric, Mitic, and Korf contains copies of a standard form with their personnel details, either undated or dated 10th of April 1992, and these, quote, substantiate the relationship to the accused, close quote. As slide 32 shows, not to be shown to the public, these forms 33. These forms do not provide any concrete evidence to support the prosecution's claim. At most, these files show they provided some personal information, nothing more. No membership of a unit, nothing that allows an inference of procurement or command by Stanišic. In the same paragraph, the prosecution points to per diems paid to some of these men, Avramovic, Cerney, Kolobric, Milkovic, and Simovic, in August of 1993, a year later. Plainly, these have no bearing on Stanisic's command during the Bosanski Samaj operation. Looking at each individual is instructive. Cerney is dealt with comprehensively in our final trial brief. As mentioned, apart from him, only Subotic and Vukovic were members of the nascent unit. The only evidence that Subotic took part in the operation in Bosanski Samaj is a comment in his personnel file P00267P6 that he was, quote, actively involved in fighting for Dubois, Bosanski Samaj and surrounding places, close quote. This leaves Vukovic as the only individual who went to Bosanski Samaj with a prior association to the accused through the nascent unit. As slide 34, not to be shown to the public, shows, according to his personnel file, P02850, he applied to join the nascent unit on the 14th of February 1992. On the 28th of February 1992, Stanišic signed a document requesting an operative check. There's no documentation that his application was answered or that he became a member. At its highest, the evidence describes Vukovic as a member of the Serbian MUP deployed to Bosanski Samaj. This is confirmed by the evidence P01938, P2562-257, a Mladic diary entry of a meeting with Todorovic, who confirms that the only men who had any connection with the S-MUP were Vuk and Cerney. The rest were volunteers from Krajovac. There's no evidence that they joined the nascent unit. Beyond their association with Cerney and Vukovic, there's nothing to suggest procurement by Stanišic. We've made detailed submissions about Mitic, Lugar and Debeli at the defence in the defence final trial brief. At paragraphs 1033 to 1045, 1063 to 1077. As slide 35, not to be shown to the public, shows, their connection to Badger through the SPWSTO explains why, as per paragraph 125 of the prosecution final trial brief, Lugar was paid by the SMUP during the Bosanski Samaj operations. Sasha Kulibric and Goran Korf also have personnel files. However, as slide 36 shows, there is no evidence to show any connection to Stanišic. Indeed, as we've argued, the evidence supports the defence case that they were SRS volunteers. Korf's personnel file, P02714, contains only one page, the undated form. His KDF file, P02031, at page 4, states he was an SMUP reservist. This is entirely in line with the defence case that these men were associated with Badger. But nonetheless, the prosecution missed other instructive evidence from his file. In particular, at page 2, he wrote that from 26th of September 1991, he was a member of the Krajovac Radical Party, Grey Wolves, under the command of Sreko Radinovic. Sasha Kulibric's personnel file, P02705, contains no information beyond 10th of April 1992 form. There's no real suggestion he had anything to do with the DB until he joined the JSO in 1998. As seen in P01709 in June 1992, Sasha Kulibric was a platoon commander in the SARS Kragujevac Chechnik detachment under the command of Debeli, who was at that point commander of the Posavina Brigade. At Annex A, paragraph 25, the prosecution alleged through P02043 that the DB were at that point trying to influence the activities and intentions of Lugar's group through Kulibric. While this is a rare moment of agreement with the prosecution, this evidence confirms that Lugar, Debeli and Kulibric were not under the command of the DB. If they were, the DB wouldn't be operatively processing them in order to neutralize their activity. The remainder of the men that the prosecution allege deployed with Cerney do not have personnel files. There's no other evidence to associate these men with the DB. They were a group of volunteers of the Serbian Radical Party under the command of Debeli, as seen in P02071. 48 at page 1. This is corroborated by numerous pieces of evidence detailed in the defence final trial brief at paragraphs 1046 to 1052. None of the evidence the prosecution cites at Annex A, paragraph 2, in relation to Avram, and at paragraph 166 in relation to Simatovic, or at paragraph 79 in relation to Lazarevic, is capable of establishing that they were members of a unit under the command of Stanišic. Only their association with Cerney. The last thing I'll mention in relation to Bosanski Samaj is the prosecution's analysis of Cerney's return to Bosanski Samaj in October of 1992. At paragraphs 126 and paragraph 560, the prosecution come dangerously close to admitting the defence case. They suggest that Stanišic personally discussed with the VRS whether Cerney would be allowed to continue operating in the Bosanski Samaj area. They allege that, quote, with Stanisic's knowledge, Simatovic redeployed Cerney's unit, including Lugar and Debeli, to Bosanski Samaj, close quote, where they joined the VRS in further operations. In other words, Stanišic merely knew of Cerney's deployment. As seen in slide 37, and elaborated in paragraphs 1081 to 1085 of the defence final trial brief, P01988 and P01989 actually exculpate Stanišic. P01989 suggests that Cerney, not the unit, but Cerney, was sent to Bosanski Samaj by Simatovic. P01989 corroborates the defence case in a very important way. It says that the Red Berets no longer existed, but could be activated by Simatovic and Curtis. I'm not suggesting that's true. That's a matter for your honours and for the Simatovic team. But it's noteworthy that in 1992, contemporaneous reports are suggesting the Red Berets have been disbanded. Stanišic has no role. And as P01988 shows, and ignored by the prosecution, 20 men referred to as Red Berets were present in Bosanski Samaj, not to help the JNA, but to stop Sechel's men taking over. In other words, not to support the RS's combat activities, but to fight the likes of Lugar and Debeli. What do the prosecution say about this evidence of procurement that has nothing to do with procurement in relation to common criminal purpose? Nothing, as usual. Moreover, the wider evidence seen on the slide when Cerney did redeploy to Bosanski Samaj, it was without an elite DB unit. As the slide shows, despite making grandiose claims of bringing 500 men, P01918 and P01924 detail that he actually brought around 20 men who were, quote, all loafers from Serbia, close quote. He had to gather the best from other units to form the so-called shock battalion. Again, what does that say about the prosecution's Red Beret theory? Cerney, critical member, not operating with an elite unit, not operating with a nascent unit, picking up loafers, stealing men from the VRS unit. Stanišic is supposed to be in command of that. As for Eastern Bosnia, the prosecution's disregard of evidence must not be permitted to prejudice Stanišic. In paragraph 574 of their final trial brief, the prosecution alleged that the unit, quote, established its Podrina regional command on Mount Taura in late 1992 or early 1993, close quote. We'll make a couple of points about this. First, the prosecution attempt to exaggerate the significance of Operation Uda. Slide 39 shows the list of operations in the Podrina region that were conducted solely in the first half of 1993. As 2D0051, 1D00914, P03664, P01944, and P03624 demonstrate, the VRS was involved in planning all of these operations with a huge number of its own units. DB had nothing to do with that. Even if Simatovic or Bozovic or Miovic was involved, it's important to see the evidence in context and not allow the prosecution to exaggerate. More significantly for Stanišic, the prosecution intentionally disregarded the evidence pointing to the existence of a special MUP, Special Forces Command or Joint Staff. Instead, they resort to the term, quote, Podrin Regional Command on Mount Taura, which is nowhere mentioned or implied in the evidence. Yesterday at transcript 76, the prosecution claimed that Stanišic was claiming that all forces of the Serbian MUP were subordinated to the main staff of the JNA. That is not our case, not the main staff of the JNA or the VJ. Our case at paragraph 1397 to 1408 is that there are a Serbian MUP Special Forces Command or a joint staff, and all the military operations were under this staff. As we discuss in paragraphs 1394 to 14415 of our final brief, that staff consisted of the VRS, the VJ, the RS MUP, and the Serbian MUP. By denying the existence of the Serbian MUP Special Forces Command, the joint staff, the prosecution hopes you will ignore the obvious. One, that the command was engaged in coordinating various military activities ostensibly designed to protect Serbs from being butchered by Oric's forces, and two, that Stanišic was not involved in these activities or the chain of command. Badger was in command of these operations, not Stanišic. This is crystal clear, again, from Milovanovic, who saw Stanišic, and as I've already mentioned, thought he was a waiter. As Exhibit 1D0070 demonstrates, and the prosecution ignore, different Serbian MUP and RS MUP police units combined and cooperated with the VRS, all acting subject to the command of the joint staff. Not a single witness or document suggests otherwise. True, Bozovic did send a report addressed to the Special Purpose Unit MUP Serbia DB Department describing an incident in Osmacha on the 9th of April 1993. There's that Trojan horse again. Despite this report, there's no doubt that all of the military activity was centered around Bina Basta, and whoever Bozovic was addressing, they were located in that region and part of the joint staff based at Tara and Bina Basta. And so, I'm coming to a close, Your Honour, but the prosecution's final trial brief, would it be possible to have 5 minutes? Then I'll be done.
Yes.
Thank you, Your Honour. Every step of the way, the only means the prosecution have to try to prove their case is to overstate evidence of relationship, or misstate or ignore evidence of command or procurement. The Special Purpose Unit MUP Serbia staff, the joint staff, is instructive. But so are the horrific executions by the Scorpions. No one should be accused of this crime unless there is reasonable evidence of it. The prosecution treat the linkage evidence as if it's a pick and mix at a sweet shop. As we describe at paragraph 1564 to 1567 of our final trial brief, in the indictment they allege that Stanišic ordered the Scorpions to deploy from their base in Delatucci to Trnovo. Then it was Badger. Now it's both accused. Also Miovic. Now Badger and Stanišic. This revolving door of implication is not only unseemly, it's the basis of miscarriages of justice, which the prosecution ought to care about, as is the prosecution's misrepresentation of evidence concerning the Scorpions at 372, 857, 643, 862, 592, and so on. And the omission of relevant, cogent, contemporaneous evidence is a real problem in the prosecution strategy. As slide 42 shows, not to be shown to the public, Stanišic contemporaneously condemned the Srebrenica killings. The prosecution knows it because Mr. Groom, Mr. Stringer's predecessor, told us. Stanišic said, quote, "What happened in Srebrenica? Who did this stupid thing? Why were the people killed? Who commanded this folly?" This the prosecution wants to ignore. And so to conclude, we have no time to go through the paragraphs of the prosecution's final trial brief and demonstrate further the scant evidence and even more scant regard for the presumption of innocence and the standard and burden of proof. The prosecution's disregard of the principle of culpability is clear. If the burden of proof was to mean anything, and if the Brajinin JCE law means anything, it should have meant three things. One, that the prosecution disclose all of their case, that they had no fear to say what it was and let us challenge it. Two, that the prosecution would put their case to our witnesses. And as we'll recall, my constant complaints, put the case to the witness, let them deal with it. And finally, the prosecution, if they want to prove their case, must engage with the doubt. Instead, the prosecution in their final trial brief and in their submissions yesterday didn't even mention it. And so, in this last point, I'm duty-bound to express my deep concern about the prosecution's final trial brief. The new evidence of allegations, evidence removed from context, direct evidence not mentioning that it was retracted in cross-examination, evidence not mentioning other relevant evidence, assertions based on partial pieces of testimony. And while we have no doubt, Your Honours, that you will review their final trial brief with care, Your Honours have been denied the essential help that a prosecutor should provide. To draft a final trial brief and ignore every piece of the 1,000 pieces of evidence showing doubt is, as I said at the beginning, a shocking abdication of responsibility. It's a strategy. And we urge Your Honours, and I hate to do this, but I urge Your Honours to allow Stanišic to respond in written form to these misrepresentations. As I say, we have confidence your chamber will read them, but you have been denied assistance. You've been denied the assistance which risks violating the principle of culpability. If the prosecution aren't prepared to grapple with the doubt, then we should be allowed to. And these submissions over the last 2 days are not enough to do so. If they're not prepared to grapple with the doubt, then it says everything about the frailties of their case. And that, Your Honours, must mean Stanišic must be acquitted. Thank you.
Thank you, Mr. Jordash. Mr. Bakrash.
Časni sude u prvom delu.
Your Honours, Mr. Petrovic will take the floor for the first part of our presentation.
The schedule is published, but your time that Mr. Jordash went over could be tacked on at the end of today's hearing.
Hvala, časni sude.
Thank you, Your Honours. That would mean that we would go until 1:30 and later continue to complete our presentation, if my understanding is correct.
the time that you would have when we come to when we come to the end of today's hearing at 4:30, then those extra minutes could be added then.
Hvala, časni sude.
Thank you, Your Honors. Your Honors, in the defense closing arguments for Simatovic, I will deal with some general allegations about the role of Franco Simatovic, whereas in the second part of our presentation, my colleague Mr. Bakrac will explain our position on the persons who are allegedly associated with Mr. Simatovic, as well as the so-called satellite units that the prosecutor is trying to associate with our client. The Office of the Prosecutor issued an indictment against Mr. Simatovic back in 2003, and it's only today, 18 years later, that we are presenting our closing arguments. The Simatovic defense believes that such a length of proceedings is due to the prosecution's attempts to create its case using flawed evidence and less than credible witnesses in order to bring the trial chamber to convict Mr. Simatovic. Before going into the detail that we want to present regarding the evidence that has been led and the allegations from the prosecution's final brief, we in fact ask the trial chamber to consider in detail every allegation made by the parties. This is especially important when we know how the prosecutor interprets the evidence very selectively by taking sentences out of context, changing their essence, and adapting them to suit their theory. The prosecutor is not only selective, he is also creative. He draws inferences and conclusions from the evidence completely loosely without looking at the totality of a piece of evidence or a witness's testimony, both in chief and on cross. The defense will ask the trial chamber to consider all this very carefully, because in this short time we cannot deal even partially with all the examples of this in the prosecutor's brief on several hundred pages. The defense will give only a couple of examples from the prosecutor's final brief and yesterday's presentation, with the proviso that this is just an example, whereas the prosecutor's final trial brief is replete with such interpretations and twists. The prosecutor alleges during the entire proceedings and in its final brief that there was a JCE aimed at using force in order to permanently remove non-Serbian population from large areas in Croatia and Bosnia, and that there was a campaign of persecution where Simatovic was one of the most prominent members from the DB of the Republic of Serbia. The prosecution claims that this plan originated in April 91 and lasted at least until December 95. The prosecutor designates Simatovic as Stanisic's closest associate, ignoring ample evidence that at least cast doubt on this allegation. In the retrial,
svojom slobodnom i
the prosecution goes a step further, and suddenly, 18 years after the beginning of the proceedings, Simatovic becomes also a close associate of Slobodan Milošević. The prosecutor claims all this without any purchase in the evidence, through loose interpretation of the material that is before the trial chamber. In para 35 of its final trial brief, the prosecutor claims that Simatovic played a key role in the SDB, and from that position of proximity with Milošević, he had a key influence on the Serbian structures outside of Serbia, which accounts for his important contribution, significant contribution to the JCE. Contrary to the prosecution claims, the defense stresses that there is not a single piece of evidence of any contact between Slobodan Milošević and Branko Simatovic during the indictment period. There was only one contact between Simatovic and Milošević, the latter being a key participant in the JCE, that is alleged against Simatovic. That was in May 1997, almost 2 years after the end of the armed conflict. That first and only meeting between Simatovic and Milošević
u kome su
was in Kula at a celebration of the JSO. It was a meeting of pure protocol where dozens of other people were present. It's especially important that even then they just exchanged a few words out of courtesy. There is no evidence at all that Simatovic was talking to Milošević, that he was informing him, that he was defining policy and strategy together with him, that he was receiving from Milošević orders or instructions. Quite simply, Simatovic's importance is very minor from Milošević's perspective. In Milošević's eyes, Simatovic is just one out of thousands of civil servants, a man with no influence or importance for state policy. In para 41, the prosecutor claims that Simatovic's de facto authority exceeded his de jure powers. The defense, however, wants to point out some circumstances that even the prosecutor does not challenge. Namely, the SDB was a very conservative, hierarchically structured service. The prosecutor, however, claims that Simatovic was able to act. In fact, we assert that Simatovic was able to act quite normally and easily with the authority and he had and the position he occupied at the relevant time. That's why it makes no sense to claim, as the prosecution does, that his de facto position was far different and greater than his de jure powers. The key principle of this service, which seems to be undisputed, between the parties is that the principle of subordination is of extreme importance for the SDB's work. For the SDB's operation from 1991 to 1995, we can clearly say that it was defined by respect for hierarchy, operation in accordance with the rules, discipline, clear relationships between levels of management. And that applied to everyone from an operative officer to the chief of service. The very structure of the service and its organization, as well as the way it was controlled and the reporting worked, leave no room whatsoever for any self-willed, independent or private action within the service at any level. There is not a single piece of evidence that any operative officer or senior officer at any level acted independently, regardless of decisions, reports, and supervision by the SDB management. The SDB is the last institution within the state apparatus where independent and self-willed action could be possible. The defense kindly asks the trial chamber to bear in mind all the evidence on the hierarchy and the organization that both formally and essentially defined DB work in the contested period. In the period from April 91 to May 1992, Simatovic was a chief of section in the SDB administration, Belgrade. That is the lowest level of management within the SDB. Simatovic was appointed head of section on the US desk on 15 December 1990. He was appointed deputy head of the second administration on the 1st of May 92. In the period up to the 1st of May 92, Simatovic's powers were limited to the affairs entrusted to his section. At this position, Simatovic was responsible for the management of the section, organization, participation, and direct execution of tasks and jobs. The work post Simatovic occupied from December 1990 to May 1992 was at the very bottom of the hierarchical ladder of the SDB. Above him were the the chief of administration, the assistant chief of the RDB intelligence department, the deputy chief of the department, the chief of the department, and finally the minister of the interior. He was 6 levels below the chief of service, that is to say 7 levels between him and the minister of the interior of the Republic of Serbia. Despite these indisputable facts, the prosecution persists in maintaining that Simatovic was the right hand of the chief of service and a close associate of Slobodan Milosevic, whereas he had absolutely no contact with the latter. Apart from that meeting in Kula, there is no evidence whatsoever about any contact between Simatovic and Milosevic. The defense will remind you that Simatovic's work post and his actual actions were limited by 7 different management levels within the Ministry of the Interior. which meant that Simatovic had absolutely no influence on decision-making of any importance within the SDB. Franko Simatovic had no involvement in decision-making in the highest state organs of Serbia or the FR Yugoslavia. He does not have anything to do with the persons who make these decisions. He has no professional contact with them. Simatovic is far below these people in the state hierarchy of the FRY and Serbia. The absence of any involvement of Simatovic in the decision-making at any level of decision-making in the state rules out any responsibility on his part regarding the key decisions related to the setting up of armed units, their financement, provision or denial of financial, military, or any other kind of assistance to Serbs in Croatia and Bosnia. That is simply quite beyond his powers, both formally and practically. Yesterday, in an attempt to show that there was a connection between Simatovic and Karadzic, the prosecutor displayed a photograph of Simatovic together with Krajišnik and Karadzic, without mentioning, however, that that photo was taken when Simatovic was accompanying the chief of service on the occasion of release of hostages. Apart from that photograph, there is no evidence that Simatovic participated in any talks, that he made, received, or transmitted Milosevic's decisions. So the purpose of showing this photograph in the absence of any other evidence was to insinuate that there was some connection between the alleged JCE participants and Franko Simatovic. This photograph is an illustration of the prosecutor's general impotence to present relevant and reliable evidence on Simatovic's connection with other alleged JCE participants. He did not attend meetings where important political, military issues were considered. He didn't attend meetings where military, political, or police decisions were made. That is quite simply far beyond his de jure and de facto position at that time. In paragraph 42, the prosecutor claims that Simatovic, contrary to the SDB mandate, acted outside the territory of Serbia from April 91. This allegation by the prosecutor is totally incoherent with the basic rules of intelligence work. Intelligence work in the SDB includes and implies and requires organizing and implementing intelligence work on the enemy territory or the territory of another state. It's especially important that Simatovic's work and deployment by his service to Knin and the Knin area in April 1991 was based on the provisions of the supreme legal act of the state at that time. The relevant provision of Serbia's constitution, namely Article 71, Para 2, stipulates that the Republic of Serbia maintains relations with Serbs living outside the Republic of Serbia in order to preserve their national and cultural and historical identity. The state organs of the Republic of Serbia were duty-bound to apply this provision of the Constitution in their work.
Časni
think
sude,
this
mislim
is-
da je sada vreme za
Your Honors, I believe it's time for the break as per your instructions.
All rise. Uye Ulave.